Hello, and welcome to In the Privy Council, a weekly podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style Blog. I'm your host, Elijah Granet. This week, we are discussing the Montserrat case of Breisford and Providence Estate Ltd, the citation for which is 2022 UKPC 46, MNT. This case concerns the system of land registration in Montserrat, which uses a comprehensive and indefeasible land registry known as Torrens Title, after its South Australian creator. In Montserrat, Section 23 of the Registered Land Act 2008, that's RLA, provides that registration of a proprietor gives said proprietor absolute ownership. Providence Estate Ltd, that's PEL, were listed as the registered proprietor of the land in Montserrat. A person pretending to act on behalf of PEL purported to sell the land to the appellants in this case, resulting in the register being changed to listing the appellants as the land's registered proprietors. PEL, on discovering the fraud, sought a court declaration, the register notwithstanding, that it remained the rightful owner of the land. Section 140 of the RLA provides that, in the case of fraud or mistake, the court may rectify the register. However, such rectification is only possible where the proprietor currently in possession of the land did not cause or substantially contribute to the fraud or mistake that led to the wrongful transfer. In all other cases, Section 141 of the RLA instead allows for indemnity by the government. In this case, the new proprietors claim that they were innocent, bona fide purchasers without any notice of fraud, and thus Section 140 was inapplicable. In this case, the new proprietors claim that they were innocent, bona fide purchasers without any notice of fraud, and thus Section 140 was inapplicable, a claim disputed by PEL. At first instance, in the High Court of the Eastern Caribbean Supreme Court, His Lordship, Acting Justice Bristol, sided with PEL on the basis that the appellant solicitors had failed to engage in due diligence, which would have revealed the fraud. The Court of Appeal, per Acting Justice of Appeal Mr. John Carrington, K.C., disagreed, finding that the requirements to defeat Section 140 were not met. However, the Court of Appeal did find that an equitable relationship had arisen due to the failure of the purchasers to carry out due diligence, meaning they did not qualify as bona fide purchasers for value without notice, that is to say, they were not equity's darlings. In the Privy Council, the appellants argue that this finding by the Court of Appeal had the effect of vitiating the purpose of the Torrens title system of indefeasible title. For the board, my Lord, Lord Kitchen, and my Lady, Lady Rose of Colmworth, focused on the question of rectification. The board began by considering the meaning of mistake. Relying in part on the English case of Enram and Evans, 2018 1 WLR 639, Court of Appeal, the board found that a mistake for the purposes of rectification was an objective question, not related to what the registrar may or could have known at the time. If the transaction is objectively void, rather than voidable, then its registration is thus a mistake. As these transactions were void ab initio, their registrations were necessarily mistaken. The next step under the RLA is to consider the contribution of the appellants to the mistake. This was straightforward. There was a complete lack of due diligence or any checks on the part of the appellant's solicitor, nor any effort to confirm that they were actually dealing with PEL. Thus, the statutory threshold for rectification was, in fact, met, and PEL were entitled to rectification due to the appellant's contribution. Having focused on rectification, the board dealt with the Court of Appeal's novel equitable findings with a short, concluding paragraph, which noted that there was neither a specific finding of fraud in the case, nor any standing conviction of the alleged fraudster. An earlier conviction had been set aside on appeal. Turning to our analysis, this case highlights the classic dilemma of a land registration system. The more indefeasible a land registry is, and in a Torrens system, it's about as certain as these things can be, the more the risk of mistake leading to unjust outcomes, as happened with this registration. The courts are naturally against injustice, but if they take a wide construction of exceptions to the register, they risk undermining the central purpose of the legislature, certainty of title. In this case, the failure of the solicitors to properly conduct any due diligence plainly made a substantial contribution to the mistake, as even the most cursory checks would have shown that they were not dealing with PEL, so the rectification threshold is quite clearly met. The Eastern Caribbean Supreme Court Court of Appeal, however, took a wrong turn by finding a novel equity in this case. The board were right to note the dangers of making findings dependent on fraud without proper evidence, but there is also a danger that importing extra equitable relationships into the RLA will undermine the indefeasibility that is at the heart of the statute. The board's clear approach for dealing with void transactions is to be preferred, and allowed an injustice to be corrected without undermining the purpose of the statute. Thank you very much for listening to this episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter, @LegalStyleblog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and God save the King.